it please the court, I'm Sylvia Walbolt here on behalf of the appellant Carlton Fields. With me at counsel table is my partner, Steve Dupre. In the order under review, the trial court sanctioned Carlton Fields for serving deposition subpoenas in anticipation of a post-trial evidentiary hearing. The plaintiffs contended that violated a no discovery order without further order of the court. The trial court sanction should be reversed for 4 reasons. First, the court did not give Carlton Fields a hearing before sanctioning it personally. Second, the court did not state the authority under which it was sanctioning counsel personally, a sanction that was not requested in the discovery motion at issue. Third, if the court was sanctioning Carlton Fields under the court's inherent authority to sanction counsel for litigation misconduct, the court did so erroneously because it did not include any factual findings of bad faith, made no finding of bad faith, no finding of litigation misconduct, much less the type of findings required under Florida law for such a sanction. And finally, there was no sanctionable misconduct because the record shows that Carlton Fields believed in good faith and with substantial justification that the trial court had agreed that this particular discovery could be taken. And I'd like to address each point in turn, beginning with the absence of any hearing. Instead, the trial court sui sponte canceled the hearing that had been scheduled on the plaintiff's motion for a protective order and simultaneously sanctioned counsel for plaintiffs having to file that motion. The motion had not requested any sanction against counsel personally, and the court did not say what authority it was relying on in doing so. But whether the court was doing so under Rule 1.380, as has been suggested on appeal, or whether it was, which is of course a fee-shifting discovery mechanism, or as part of its inherent powers, in either event, the court was required to afford Carlton Fields a hearing before sanctioning it personally. Rule 1.380 expressly requires a hearing. The plaintiffs have, on appeal, cited federal decisions saying that briefing is enough to satisfy the requirement for a hearing. Those cases were decided under the federal rule at the time that it mirrored the Florida rule. But since then, the federal rule has been changed to make it clear that written submissions are sufficient. But the Florida rule remains the same, and it expressly requires a hearing. And the first district in Arrigo Motor construed Rule 1.380 to require a hearing. In fact, it was very much what happened here. The judge canceled the hearing on the discovery motion, entered the sanction, and the first district reversed, saying there must be an opportunity for a hearing. And I suggest that this court should follow its sister court in requiring this basic due process, particularly because that's consistent with the decision of the Florida Supreme Court in Moakley, where the court described opportunity to be heard, which is the same language that is now in the federal rule, which allows written submissions. The Florida Supreme Court described that language as requiring a hearing at which there can be a, quote, opportunity to present witnesses and other evidence. And we submit that hearing should be construed in the same way for purposes of a Rule 1.380 sanction against counsel personally. The plaintiffs also argue on appeal that the 4th District's en banc decision in Auburn establishes that no hearing was required. but that case specifically addresses Rule 1.530, the rule governing motions for new trial. That rule has no requirement for an opportunity for hearing or an opportunity to be heard, unlike Rule 1.380. And likewise, if the court was sanctioning Carlton Fields under the court's inherent authority to sanction litigation misconduct, it's absolutely clear that Florida law requires a hearing at which evidence can be presented. The Supreme Court's decision in Moakley and its progeny cited in our papers make that clear. So given the lack of any hearing before the court's sui sponte sanction of counsel, we submit the sanction must be reversed for this reason alone. Secondly, reversal is required, we submit, because the court did not state the basis for its sanction against counsel personally. In our papers, we've cited decisions of both the 4th and the 5th districts that make it clear that the basis for a sanction should be articulated by the trial court. Indeed, it's only in that way that this court can properly, I submit, exercise its review powers. Third, if the trial court was exercising its inherent authority to impose a monetary sanction against counsel personally for litigation misconduct, the trial court was clearly required under Moakley and its progeny to make express and detailed findings of bad faith litigation misconduct. Moakley makes it clear that this is an extraordinary remedy for the most extreme type of litigation misconduct, not a service of deposition notices we would submit. And certainly the trial court, in entering the sanction, doesn't say it was done so based on a finding of bad faith by Carlton Fields, much less that Carlton Fields acted, quote, solely for bad faith purposes as required under Moakley and this court's recent decision in Rush. Now, plaintiffs argue on appeal, and again I emphasize that the motion itself did not seek a sanction of attorney fees against Carlton Fields, and it didn't cite any authority for such a sanction because it wasn't asking for that. On appeal, they argue that the sanction should be affirmed under the fee-shifting provisions of Rule 1.380, and thus there's no need for a finding of bad faith. But this appeal is the first time that Rule 1.380 was referenced by plaintiffs as a basis for attorneys' fees. And under this court's decision in Liebreich, a sanction should not be affirmed as right for any reason based on a discovery rule that's not cited in the motion. And indeed, in Moakley, the Florida Supreme Court specifically said that if a trial court is sanctioning counsel under a specific rule, it should do so. It should say so, that it's relying on the rule. And here, the trial court did not cite Rule 1.380 in sanctioning counsel. The ramifications to Carlton Fields from an order saying it is being personally sanctioned without any specific tether to the fee-shifting provisions of Rule 1.380 are plain. And this sanction on an unstated basis should not be affirmed, consistent with this court's decision in Liebreich. And finally, and importantly, reversal is required of this sanction because Carlton Fields did not act in bad faith, and it had substantial justification for serving the deposition subpoenas. Here's what the record shows. There was an order precluding further discovery absent a court order allowing discovery for good cause shown. The plaintiffs noticed an expert deposition in anticipation of the upcoming evidentiary hearing that was going to be held on their motion for sanctions against both the defendants and Carlton Fields. The defendants objected citing the no discovery order that had previously been entered, and a hearing was held on whether that deposition could be taken by the plaintiffs. During the course of that hearing, the trial court acknowledged that both parties would want to depose any experts who were going to testify at the hearing, and this is at pages 34 through 36 of the transcript. And in fact, the trial judge specifically responded, yeah, quote, yeah, when Carlton PL said it would be entitled to depose any expert who was going to testify for the plaintiffs at the hearing. And that's at page 35. This is the December 6th hearing transcript at page 35. So given the trial court's apparent acknowledgement that discovery was going to be appropriate of witnesses who would be testifying at the upcoming hearing, Carlton Fields then specifically advised the court that it wanted to depose plaintiffs' fact witnesses, to which the judge responded, quote, all right. That's at page 36. Now the judge goes on to say no experts. And let me pause to say that the colloquy had developed. It was clear the judge felt that expert testimony was not needed, not appropriate on the issue of whether there had been wrongful litigation conduct. The defendants agreed they wouldn't call an expert, and so the judge said, you know, if the defendants don't call an expert, you're going to want to depose their expert. If they agree not to call, there won't be any expert testimony. But when the judge went on to say no experts, at that point the plaintiff's counsel interrupted the judge to ask for leave to brief the issue of whether expert testimony would be appropriate. But they did not say there should be no discovery of their fact witnesses. Carlton Fields understood the trial court's statements at that hearing that he had agreed that if persons who were going to actually testify at the hearing, Carlton Fields could take the requested fact discovery. And that was the basis on which Carlton Fields proceeded to issue the deposition subpoenas. We submit there's no bad faith, there's substantial justification, and at a minimum, is entitled to a hearing, is entitled to be told the basis on which it was being entered, and if it was being entered on the basis of inherent authority to sanction counsel for litigation misconduct, the court should have entered findings detailing the basis on which that sanction was entered. Thank you.
Thank you, Ms. Wellbolt.
Good morning. My name is Patrick Chidneys of Holland and Knight. I represent the Appellees. With me is Joe Varner. The appellant in this case, as counsel for the defendants below, is challenging a $1,000 award of sanctions that compensated the Appellees their expenses incurred in connection with obtaining a protective order. Now, significantly, in the initial brief, the appellant stated they did not challenge the propriety of the trial court's decision to grant the protective order and prohibit the depositions, nor do they appear to challenge the reasonableness of the amount of the sanctions. The challenge is expressly limited to the decision to award sanctions. Now, the appellant's argument to this court simply misunderstands or misstates the basis for the trial court's ruling, as they argued in the initial brief principally and also in their reply that the trial court relied on its inherent authority to sanction litigants for bad faith misconduct. As the answer brief explains, this modest sanction award was proper, authorized, and in fact mandatory under the rules of civil procedure. And to provide a bit of background on how things led up to this protective order, the Appellees originally filed this suit in the trial court for fraud and inducement and breach of contract based on the sale and purchase of a group of ambulatory surgery centers. The trial court then bifurcated the tort and the contract claims, with the contract claims to go first. As a result of ongoing discovery violations and other misconduct, the Appellees filed a motion for sanctions. That motion, which comprises nearly 7 of the 9 volumes of the record that the appellant designated in this case, was originally set for hearing on October 31st, 2013. Now, after the motion was scheduled for hearing, the trial court entered a stipulated order that postponed the Phase 2 trial. In that order, the court expressly stated, and the parties agreed, discovery cutoff is not extended, and that no further discovery will be allowed except upon motion and order for good cause shown. The appellees intended to offer expert testimony during the hearing on the motion for sanctions. They noticed the deposition of their expert to preserve his testimony, and in response, the defendants moved to strike that notice of deposition. In their motion to strike, the defendants stated, all discovery deadlines have since passed, and the parties recently stipulated that no further discovery would take place in this case. So the court holds a hearing on the motion to strike and another motion to strike that they filed. During that hearing, defendants' counsel stated, the parties agreed here and you entered an order, no more discovery. No more discovery, no Ben Hill, no experts, no nothing. They agreed on that. The trial court granted the defendant's motion to strike the notice of deposition. Then on January 10th of this year, the defendant's counsel emailed 4 subpoenas that commanded the appellee's counsel to appear for deposition the afternoon before the evidentiary hearing was scheduled to be held. In response to the subpoenas, the appellees moved for entry of the protective order that's at issue in this case. The appellees explained that just as the defendants had argued during the hearing on their motions to strike and in their motion to strike, the stipulated order barred any additional discovery absent a motion that demonstrated good faith. The appellees specifically requested entry of a protective order and an award of their, quote, fees and costs incurred in connection with this motion, close quote. The defendants then filed a written response to the motion for protective order. They advanced several arguments, including their main argument in this appeal, that there was good cause to seek the discovery and that the court had authorized the depositions. They didn't mention the motion requirement in the stipulated order. After receiving the response, the trial court canceled the hearing on the motion for protective order, granted the motion, and awarded the appellees a $1,000 award of, quote, their costs incurred in having...
Counsel.
Yes, Your Honor.
Isn't the real issue in this case is whether or not Carlton Field should have been told what it was they did and given an opportunity to be heard in response to it? And isn't it really their position that Moakley versus Smallwood controls? Your position is that the rules 1.280 and 1.380 control. Isn't that really what we're talking about here?
Yes, Your Honor. I think
Okay, so help me understand why you think the rules don't allow for Carlton Fields to have been told what it was that the court believed they did and given an opportunity to respond to that in the hearing.
Your Honor, respectfully, I believe the motion was for protective order, and I think there's only one rule of civil procedure that talks about motions for protective order. Our motion on its face said motion for protective order. They filed a written response, and the court entered an order on the motion. The order is titled Order on Motion for Protective Order and Motion to Quash. The court says order is granted, they're awarded their fees incurred in connection with filing the motion. I think it's apparent on the face of the order that the trial court was referring to protective orders and that the trial court did not resort to its inherent authority to sanction litigants. I think that's consistent with the court's general obligation to affirm a trial court order if there's any reason apparent on the face of the record to do so. For example, I think if the trial court had entered an order just saying granted and not explaining where it came from, because this court can tell from our motion and their response that we were talking about a motion for protective order and the rules of civil procedure automatically require an award of fees if that motion is granted, then the order in this case should be affirmed based on the record. I think it's also apparent on the face of the order that we were talking about protective orders, not the inherent authority to sanction litigants. I think they were fully aware, and what's more...
But counsel, if I start off with 1.280, it sends me back to 1.380 as to the award of expenses.
Yes.
And that provision tells me if the motion is granted and after opportunity for hearing. And that's just a point that Judge Morris is making, after opportunity for hearing.
Certainly, and I believe that the appellant was fully afforded an opportunity to be heard, and I recognize what the rule says after opportunity for hearing. Now, the advisory committee notes to the Florida rule states it was patterned after Federal Rule Civil Procedure 37. Now, before 1993, Rule 37 was almost exactly like Florida's rule. I mean, it tracked the same language, opportunity for hearing. In 1993, the federal courts amended that rule, and the advisory committee notes to the 93 amendments state this was to make clear that written submissions were sufficient. So if you go back and you look at the federal cases...
How is that binding on an earlier Florida rule? And can I make that, that assumption?
I believe that the case law indicates that the federal courts found that opportunity for hearing is satisfied by written submissions, and I believe the advisory committee note amendment says it was to make clear. It was not to affect a substantive change in the rule.
Prior to the amendment.
Yes, the case law is all prior to the amendment. And
but we all know you don't get a hearing for anything in federal court. The tradition and history in our state court system is you set things for hearing. We have an opportunity to make your pitch to the judge.
I believe that might have been the case had they not had the opportunity to submit a written response that outlined their positions. And maybe more importantly here, they haven't identified a single issue in the course of this appeal that they were not entitled to present or weren't able to present in their written response. I could see a situation where maybe there were a factual dispute, you needed to take evidence or something. But absent something that they have identified in this appeal that they couldn't present to the trial court in writing, and which they did not present to the trial court in writing, I don't think there's any reason to elevate form over substance here and say that that literal language, which the federal courts clearly said, we can deal with this in writing if you want to. They didn't say in this appeal at any point that there was something they needed a hearing on. They presented the same arguments in this appeal that they presented in their response. And I think some of the federal cases are sort of instructive. For example, in Toretto versus IB Diffusion, the court said the plaintiff is correct that Rule 37 states expenses are to be imposed after hearing. Nonetheless, this court agrees that the parties' submissions and their responsive memoranda constitute the hearing. That case actually cited to another case, Person versus Fastel, where the court said it, under the circumstances, it's somewhat bizarre that for plaintiffs to ask for a hearing on the subject as though they had not already been heard. Finally, in a case called Addington versus Mid-Atlantic Lines, the court noted 37's requirement for an opportunity for a hearing, but added that because both the parties had fully expressed their positions in writing, the hearing requirement was satisfied. And I think that really goes back to the point here. The appellant hasn't identified a single ground that would require an additional in-person hearing.
Does it make a difference that the judge asks, the parties submit memoranda
Correct.
and whatever, and then there is a hearing scheduled?
Correct.
And at the last minute, the judge calls, cancels the hearing, and sends out an order. And as I read some of those other cases, it just seems as a matter of practice, the written submission will substitute for a hearing.
Correct.
Does it make a difference the way the trial judge handled this?
I don't believe it does, because on appeal, and we now have the benefit of retrospect, they haven't identified some issue that they were deprived of by losing that hearing, and I think that's very significant. Also, I think that it's important to understand that in the complex business division, there are local rules of procedure, and any substantive motion has to be accompanied by a memorandum of law. That's not the same in normal state court. So I would submit that the complex business division, the standard is probably on written submissions, and that's consistent with the purpose of the complex business division, which is to increase efficiency, reduce technical delay. That's actually in the rules. So when you have written submissions being the norm and their objective is to decrease cost, to say that there should be an in-person hearing in addition to a situation where the parties have fully briefed the issue, I think that's extremely inefficient, and it would greatly increase the cost. It would have increased the cost to my client had they had a hearing in addition to the written submissions. And again, the point here is there's no reason for there to have been an in-person hearing in this case. They haven't identified one. Unless the court has other questions on the hearing issue, I'd like to briefly mention the notice matter that they stated. They said that they weren't aware of the fact that we were requesting fees. The motion for protective order actually states that we were requesting an award of fees and costs incurred in connection with the motion. I think that's apparent on the face of the motion that we were requesting fees, and that language tracks Rule 1.380's requirement for fees and for expenses incurred in connection with the motion, which is also on the face of the order. Now, unless the court has any other questions about the operation of 1.380, I think that the argument about inherent authority being the basis for the court's ruling simply overlooks the face of the order and the face of the motion. Under the operation of Rule 1.380A4, an award of expenses is the default. It's automatic, absent additional findings. And those findings weren't made in this case, and they haven't demonstrated a reason that the trial court abused its discretion in not making those findings. The defendants in the trial court sought discovery without ever seeking a motion or demonstrating good cause, which is required by the stipulated order. Moreover, their counsel had unequivocally argued that the discovery deadlines had passed, and they took a position inconsistent with that. And finally, scheduling the depositions unilaterally was a violation of the complex business litigation division rules. They haven't demonstrated a basis to overturn the sanction award under Rule 1.380. Unless the court has any other questions on that, I'd also like to point out that we filed a motion for an award of our appellate attorney's fees under the same fee-shifting concept that exists in Rule 1.380. We cite to a decision from the Seventh Circuit Court of Appeals titled Rickles versus the City of South Bend, Indiana. In that case, Judge Easterbrook explained that Federal Rule 37, again from which Rule 1.30 is derived, is a fee-shifting rule. It's not a sanction rule. And he says that the purpose of a fee-shifting rule is to make every loser to make every victor whole. He states that the purpose of the fee-shifting rule can't be satisfied if the victor must pay for the appeal out of his own pocket, as in the cost wouldn't be completely shifted as the rules intended to operate. Unless the court has any other questions, the appellees request that the court affirm the order on appeal and award the appellees their reasonable costs and expenses incurred in this appeal. Thank you.
Mr. Sheets.
Very briefly, may it please the court, counsel is absolutely right that the motion for protective order asked for an award of fees, but as I said in my opening remarks, they didn't ask for an award of fees against counsel personally, and they didn't cite any authority, much less Rule 1.380 as authority for awarding fees against counsel personally. Yes, the court ordinarily affirms a trial court if it's right for any reason in the record, but this court refused to do that in Liebridge, and it should refuse to do that here. Having a sanction against a law firm personally is a serious matter. We appreciate that. And the order should reflect the basis upon which it is being entered, and only on that basis should it be affirmed if the record shows that is correct. Counsel refers to briefing, and it's true, there was briefing on the motion. There was not briefing on the sanction, at least before the sanction was entered, because no sanction had been asked against Carlton Fields personally. Counsel says there's no need for a hearing. Certainly there was a need for hearing, and we did ask for one. We specifically objected after receiving notice of the oral ruling, which canceled the hearing we had expected to go to address these issues, and there were indeed factual disputes that could have been addressed at a hearing, including the substantial justification that we believed we had for filing these notices. We would ask that this order be reversed and that the request for attorney's fees be denied. Thank you.
Thank you, Ms. Baldwin. Thank you all.
Okay. Next case is